Thank you, Madam President. I think that the question of the basis for a vote on judges is one of the least clear duties that we have here in the legislature. It's pretty obvious what we're doing when we vote on a bill, but it seems to me that when we vote on a person nominated for a position, it's less clear what our criteria would be. I can't speak to this with expertise on the state level, but I have some sense of the history of this on the federal level. It's very interesting to me. Almost from the moment that partisanship began with the death of George Washington, appointments to the Supreme Court became a matter of pitched battle at the federal level, beyond anything that we've witnessed in our time. Thomas Jefferson tried to get his allies in the Congress to impeach Justice Marshall, for instance, not on any grounds of competence, obviously, or character, but simply because they philosophically opposed one another. And I think we've gone through periods since of, let's say, eras of good feeling, where the assumption is if the candidate is generally qualified and of good repute, the opposing party will go along with it. And we've had periods where the fight has been more pitched, including in our own time. I think the lesson of that is it's something that we have to figure out ourselves on what basis we make such a decision. It seems to me that there would be three things in my own mind that I would consider. And in the case of Andrew McDonald, we'll say the first one would be questions of character. I've heard nothing but positive things about him from both sides as a colleague, for his intelligence, his ability to work with people. Like all of us, not a perfect human being, but not somebody who has attracted the kind of questions that would make me think that his character was such that he needs to be opposed on those grounds by any means. The second one I would think of is what has his record been as a judge being appointed to the Supreme Court. Now, clearly, here we say, well, he's in that rare category of Supreme Court nominees that does not have a judicial record. The fact that we have to look back first to Governor Weiker's administration, for one example, and before him all the way back to Governor Grasso, indicates how rare such an appointment is. I saw in columns written about his qualifications comparisons of the name of Earl Warren brought up as an example of a judge of the Supreme Court who had not previously served as a judge. That's going back almost 60 years for a similar example. It doesn't mean in my mind that I would oppose it because he hasn't served as a judge, but it means there's no record there to examine. So I think the third thing that exists for us to look at is his judicial philosophy or his outlook. And in light of the fact that he's being appointed to the Supreme Court, I think it's his attitude towards the Constitution above all which would concern me. And I have to say, in the case of his experience as senator, as Senator McLaughlin has pointed out, his involvement with a bill that I think is largely considered the most questionable questionable piece of legislation proposed from a constitutional point of view in living memory, I think that weighs very heavily against him. And in my own experience, it's something that I've been involved in. I was, along with a number of other people from the disabled community, from the home care community, I was involved in a lawsuit concerning the forced unionization issue. That suit was brought on two grounds. One was the constitutional grounds, the question of the governor's ability to, by executive order, move forward with the forced unionization. An aspect that was mooted largely by the action of the legislature in passing the bill ultimately that ratified what the governor had done. The second ground was a matter of labor law, the appropriateness of what was done in the legislation. In that, I had to trust our lawyer, who was a man with over 30 years' experience here in Connecticut in labor law, not a political lawyer, so to speak, but a labor law expert, who felt that we had a strong case, a case that seemed viable insofar as I understood it. What disturbed me about that experience was Senator McDonald's dismissal of the case out of hand in commenting on it on behalf of the governor's office. Comments that I think were felt to be rather, let's say, not respectful of the concerns of the party that were involved in it, and especially the fact that he characterized it as being a radical suit. Now, this may have been a reflection of the legislators' names who were attached to it, but I don't think there was anything in the body of the suit or in the presentation that we made that could be considered radical from the point of view of anyone whose constitutional outlook was in the mainstream as I see it. Both those cases are enough to convince me that Senator McDonald's outlook is not one that I would choose to see on the Supreme Court, and for that reason I will oppose this nomination. Thank you.